Welcome to the 51 practice questions for Chapter 12, Law of Agency, as part of your UBC real estate exam prep. This chapter covers essential concepts like agency relationships, fiduciary duties, and legal obligations in real estate. These practice questions are designed to test your understanding and reinforce key points, helping you prepare confidently for your exam. Let's dive in and sharpen your knowledge on the law of agency.
Chapter 12, Law of Agency. Question 1. Under the rules, what must a listing licensee do if the seller instructs them to withhold the disclosure of a material latent defect to a potential buyer of the property? Correct answer. The listing licensee must refuse to provide further trading services to or on behalf of that client in respect of the trade in real estate. Explanation. Under the rules, if a seller instructs a listing licensee to withhold the disclosure of a material latent defect, the licensee cannot comply because doing so would violate their ethical and legal obligations. Instead, the licensee must refuse to continue providing trading services to or on behalf of that seller for the specific transaction. This ensures the licensee does not facilitate a sale that might harm potential buyers due to non-disclosure of important defects. Other options. 1. The listing licensee must disclose that material latent defect to the buyer. Incorrect. While disclosure of a material latent defect is required under the rules, a licensee cannot disclose it without the seller's permission. If the seller refuses, the licensee must stop acting for the seller instead of disclosing the defect without authorization. 2. The listing licensee must report the situation to the British Columbia Financial Services Authority. Incorrect. The British Columbia Financial Services Authority, BCFSA, oversees regulatory compliance, but the immediate requirement in this situation is for the licensee to refuse to provide further trading services, not to report to BCFSA. Reporting may occur as a subsequent step depending on the specific circumstances. 3. The listing licensee must follow the seller's instructions and withhold disclosure to potential buyers. Incorrect. Withholding disclosure of a material latent defect would violate the licensee's legal and ethical obligations. They cannot comply with such an instruction from the seller. Key takeaway. The correct course of action is to cease providing services to the seller rather than compromising professional responsibilities or breaking the law. Question 2. Ellie, a licensed real estate representative, entered into a written exclusive listing contract with Laura to list Laura's house for sale for $300,800. Shortly after entering into this agreement, Ellie's license expired. Unaware of the expiration of her license, Ellie proceeded to hold 3 open houses and several other showings of the house, eventually finding a buyer who offered $300,800 for the house. Laura accepted the offer, but when she learned about Ellie's license expiry, she refused to pay any commission to Ellie. Which of the following statements is true? Correct answer. A court will not award Ellie any form of remuneration in this situation. Explanation. Under the Real Estate Services Act, RESA 1, unlicensed activity, a person must hold a valid real estate license to legally provide trading services and earn a commission. Since Ellie's license had expired, she was not authorized to act as a real estate representative when she conducted open houses, showings, or facilitated the sale. Real estate licensees must ensure their licenses remain valid to lawfully provide services and claim remuneration. 2. Invalid commission claim. RESA prohibits unlicensed individuals from suing for commission or remuneration for real estate services. Even though Ellie performed these services, her lack of a valid license means she cannot enforce the contract or collect payment. Why other options are incorrect? 1. The Real Estate Services Act permits Ellie to sue Laura for commission in this situation. Incorrect. RESA explicitly prohibits unlicensed individuals from suing for commission, regardless of the terms in the listing contract. 2. A lawsuit to recover damages against Laura for breach of the listing contract will probably succeed. Incorrect. Since Ellie was not licensed at the time of her services, the contract is unenforceable under RESA. Laura's refusal to pay is legally justified. 3. The listing contract likely violates the statutory requirements of the Real Estate Services Act. Incorrect. The listing contract itself might meet statutory requirements, but Ellie's actions after her license expired rendered her unable to legally fulfill or enforce the agreement. Chapter 12, Law of Agency. Question 4. Adele is a trading services licensee acting for a developer who is purchasing large blocks of land in Vancouver for a large development. Adele purchases some lots in the area for himself and discloses his identity to the sellers as required by the Real Estate Services Act on those purchases. He does not mention the purchases to his principal, the developer. Shortly thereafter, Adele makes a profit on the resale of his lots due to the effects of his principal's development on the real estate market. What is this an example of? Correct answer: a profit for which Adele must account to his principal. Explanation: Adele's actions violate the fiduciary duty of undivided loyalty that a licensee owes to their principal, the developer. As a fiduciary, Adele must prioritize his principal's interests and disclose any personal dealings that could result in a conflict of interest or personal gain related to his principal's activities. Adele's profit, gained through insider knowledge and without the principal's informed consent, is an example of a fiduciary breach. He must account for those profits to his principal. Here's why. 1. Use of confidential information. Adele used insider knowledge gained through his work with the developer to purchase lots for his personal gain. Even though he disclosed his identity as required by the Real Estate Services Act, failing to inform the principal is a breach of fiduciary duty. 2. Duty to account for profits. Any profit made from actions related to the principal's affairs must be disclosed and accounted for, as the principal may have chosen to purchase those lots themselves if informed why other options are incorrect. 1. A good business deal that is perfectly acceptable at law. Incorrect. Adele's actions are not acceptable at law because they breach fiduciary duties owed to the principal. 2. A use of information that will always, even with disclosure to the principal, be prohibited. Incorrect. While misuse of confidential information is prohibited, the key issue here is Adele's failure to inform his principal about the opportunity and his actions. Not that disclosure would always make such actions impermissible. 3. Adele's activities are examples of both 2 and 3. Incorrect. Disclosure to the principal might have remedied the issue, depending on the circumstances, so this option is too broad. Chapter 12, Law of Agency. Question 5. An agent will be personally liable to third parties. Correct answer: where the agent fails to disclose that they are an agent. Explanation: an agent's liability to third parties depends on the disclosure of their agency relationship and their authority to act for the principal. 1. Failure to disclose agency. If the agent does not inform the third party that they are acting on behalf of a principal, the agent is personally liable for the contract. The third party assumes they are dealing directly with the agent. 2. Contracting on behalf of a principal. If the agent clearly discloses they are acting for a principal, the liability generally falls on the principal, not the agent. Therefore, this option does not always make the agent personally liable. 3. No written authority. While written authority, like a power of attorney or contract, can strengthen an agent's position, an agent does not always need written authority to bind a principal. Oral or implied authority can also suffice, depending on the situation. Why other options are incorrect? Whenever the agent contracts on behalf of a principal. Incorrect. If the agency relationship is disclosed and the agent has authority, the agent is not personally liable. The principal is. Where the agent has no written authority. Incorrect. Written authority is not always required for an agent to act or avoid personal liability. In all of the above circumstances, incorrect, personal liability does not occur in all of these situations, only when the agency relationship is not disclosed. Key takeaway: an agent will be personally liable to third parties if they fail to disclose that they are acting as an agent for a principal. Disclosure is critical to avoid personal liability. Question 6. An agency contract that specifies that the real estate brokerage shall be the sole agent for the owner with respect to the sale of property is called. Correct answer: an exclusive listing. Explanation: an exclusive listing is an agency contract where the real estate brokerage is designated as the sole agent for the owner regarding the sale of a property. This means 1. The owner agrees to work only with that brokerage for the sale. 2. The brokerage has the exclusive right to market the property. 3. If the property is sold during the term of the exclusive listing, the brokerage may be entitled to commission, even if the sale was arranged by the seller or another party. Why other options are incorrect? In open listing. In an open listing, the seller may list the property with multiple brokerages and pay a commission only to the one that procures a buyer. A general listing. This term is not a common formal classification of listings. It may refer to listings with minimal restrictions, similar to open listings. A restricted listing. This is not a standard term in real estate contracts. Key takeaway. An exclusive listing ensures that the brokerage acts as the sole agent for the seller regarding the sale of the property. Chapter 12, Law of Agency. Question 7. A licensee is required to provide the consumer with a disclosure of risks to unrepresented parties form if the licensee is providing trading services to the consumer as an unrepresented party in such a way that the licensee must provide a disclosure of representation in trading services form to that unrepresented party and answer. The licensee is also representing a client in the same trade in real estate. Explanation. Under the Real Estate Services Act, RESA, a licensee must provide a disclosure of risks to unrepresented parties form if they are offering trading services to an unrepresented party and simultaneously representing a client in the same transaction. This ensures that the unrepresented party understands the risks involved, such as 1. Conflicts of interest. The licensee's loyalty is to their client, not the unrepresented party. 2. Limited assistance. The licensee cannot provide advice or negotiate on behalf of the unrepresented party. 3. Potential disadvantages. The unrepresented party may not fully understand the trade and may be at a disadvantage without independent representation. Why other options are incorrect? 1. The unrepresented party is particularly vulnerable in the trade in real estate. While vulnerability may raise ethical concerns, it does not specifically trigger the requirement for this form. 2. The unrepresented party is not obtaining legal advice in respect of the trade in real estate. A licensee may recommend that unrepresented parties seek legal advice, but this situation does not directly require the disclosure of risks form. 3. The unrepresented party has never worked with a real estate licensee before. Experience with real estate transactions is irrelevant to the requirement for this disclosure. Key takeaway. When a licensee is representing a client and simultaneously interacting with an unrepresented party in the same transaction, they must provide the unrepresented party with a disclosure of risks to unrepresented parties form to ensure informed consent and clarity. Question 8. If, under a principal's instructions, an agent makes certain representations concerning a property that are false to the knowledge of both the principal and the agent, which of the following statements are true? Correct answer. All of the above. Explanation. 1. The principal is liable because they explicitly authorize the tort. If the principal knowingly instructs the agent to make false representations, the principal is liable as they are the source of the misrepresentation. 2. The agent cannot escape personal liability by arguing that they were authorized to commit the tort. Authorization by the principal does not absolve the agent of personal liability for committing a tort, e.g., misrepresentation. 3. The agent will be personally liable for the tort. Both the principal and the agent can be held liable. The agent is directly responsible for their actions, even if instructed by the principal. Thus, all of the above statements are true. Question 9. If there is no listing contract in existence, but the agent effects a sale of the principal's property at the request of the principal, the courts will answer. B. Imply a promise to pay the agent remuneration. Explanation. If an agent effects a sale of a property at the principal's request, even without a formal listing contract, the courts may imply a promise to pay remuneration. This is based on the principle of quantum meruit, reasonable compensation for services rendered, because the agent has performed work at the request of the principal and created a benefit for them. The courts recognize that it would be unfair for the principal to benefit from the agent's efforts without compensating them, even in the absence of a formal agreement. The principle of quantum meruit applies here. If an agent performs services at the principal's request and secures a sale, the courts will imply that reasonable remuneration is due. Other option analysis. not imply an undertaking to pay the agent remuneration. Incorrect. Courts will often imply a promise to pay if the agent's services were requested and resulted in a benefit to the principal, even without a formal contract. C. Allow the agent to collect only their out-of-pocket expenses. Incorrect. While out-of-pocket expenses might also be recoverable, the courts will generally go beyond this to award reasonable remuneration for the agent's services. D. Hold the agent liable for any default of the buyer. Incorrect. The agent is not liable for the buyer's default unless the agent acted improperly or misrepresented facts. Question 10. The type of agency relationship that describes the situation where the licensee represents only one party as a client in a given transaction is called A. Correct answer: sole agency relationship. Explanation: in a sole agency relationship, the licensee represents only one party, either the buyer or the seller, as a client in the transaction, ensuring loyalty, full disclosure, and other fiduciary duties. Other options: no agency relationship. Incorrect. This describes a situation where the licensee does not represent either party as a client, but may still assist them as an unrepresented party. Limited dual agency relationship. Incorrect. Limited dual agency occurs when the licensee represents both the buyer and the seller in the same transaction, with consent from both parties. Full agency relationship. Incorrect. This term is not commonly used in real estate to describe an agency relationship. It might be mistaken for sole agency, but it lacks specificity. Summary: the correct answer is sole agency relationship, as it specifically refers to representing only one party as a client in the transaction. Question 11. A prospective buyer signs an offer on a property for $250,000 and mentions to the listing licensee that she would be willing to pay as much as $270,000 for the property if necessary. The listing licensee presents the offer to the seller without mentioning that the buyer may be willing to increase the offer. The seller accepts the offer of $250,000. This fact pattern is: answer, a breach of the agent's legal and ethical duty of full disclosure to her principal. Explanation: the listing licensee must disclose all material information that could influence the seller's decisions, including the fact that the buyer is willing to pay up to $270,000. Failing to disclose this breaches the fiduciary duty of full disclosure. Other options: an example of the agent's ethical obligation to deal fairly with the buyer at all times. Incorrect. While the licensee must deal fairly with all parties, the duty to the principal, seller, comes first. The agent's obligation to disclose any information that could benefit the seller overrides this. Acceptable conduct on the part of the agent. Incorrect. Withholding material information from the seller is not acceptable. The agent failed in their legal obligation to act in the seller's best interest. An example of the agent's duty not to make a secret profit. Incorrect. This situation does not involve the agent making a secret profit. That typically occurs when the agent benefits financially without the knowledge or consent of the principal. Summary: the correct answer is a breach of the agent's legal and ethical duty of full disclosure to her principal, as the agent failed to share information that could have led the seller to negotiate a higher price. Question 12. Alan is Peter's agent with the express authority to rent Peter's cottage for the summer months. However, in his capacity as Peter's agent, Alan accepts an offer to purchase the cottage instead. When Peter discovers the incident, he is so impressed by the price, he calls and tells the buyers that he adopts Alan's act. Which of the following is the result of these actions at law? Correct answer: Peter has ratified Alan's actions, therefore the buyers cannot sue Alan for breach of warranty of authority. Explanation: ratification occurs when the principal, Peter, adopts or approves an unauthorized act performed by the agent, Alan. Since Peter accepted the deal after discovering it, the act is retroactively validated, and Alan is no longer liable for exceeding his authority. Other options: 2. When Peter adopted Alan's act, he created legal authority by means of revocation. Incorrect. Ratification creates authority retroactively, but it does not involve revocation. Revocation refers to ending an agent's authority, not approving unauthorized actions. 3. Peter did not need to adopt Alan's act because Alan had apparent authority. Incorrect. Alan's authority was express and limited to renting the cottage. There was no apparent authority perceived by third parties, to sell the cottage. Summary: the correct answer is Peter has ratified Alan's actions, therefore the buyers cannot sue Alan for breach of warranty of authority. Ratification validates the unauthorized act and protects the agent, Alan, from liability. Question 13. Where an agent with authority enters into a contract with a third party and does not disclose that they are acting as an agent. Correct answer: A. The third party may sue either the agent or the principal to enforce the contract. Explanation: if the agent does not disclose that they are acting as an agent, the law treats the agent as a party to the contract. The third party can enforce the contract against either the agent or the undisclosed principal when the principal is later revealed. Other options: 2. The principal may sue the agent to enforce the contract. Incorrect. The principal does not need to sue the agent to enforce the contract. Once the principal's identity is disclosed, the principal can directly enforce the contract against the third party. 3. Only the agent may sue the third party to enforce the contract. Incorrect. The principal can also sue to enforce the contract once they are disclosed, even if the agent did not reveal their role initially. 4. There is no contract in existence because there is no disclosure. Incorrect. A contract exists even if the agent did not disclose their status. The agent is personally liable until the principal is identified. Summary: the correct answer is A. The third party may sue either the agent or the principal to enforce the contract. In cases of undisclosed agency, the agent is treated as a party to the contract, but the principal can also be held liable once identified. Question 14. Steve and, a trading services licensee, has been asked by her friend, Jane, to find a house, and if successful, Jane has agreed to pay Steve and the sum of $3,000 over and above any commission that Steve and would earn on the sale of the property. When Steve and finds a house acceptable to Jane, Steve and shares the commission with the other licensees involved and receives $3,000 directly from Jane. Steve and does not tell anyone of this $3,000 payment. Which of the following statements are true? Correct answer: C. Both 1 and 2 are true. Explanation: 1. Steve and has breached the provisions of the Real Estate Services Act. True. The Real Estate Services Act requires full disclosure of any remuneration received in connection with a real estate transaction. By failing to disclose the $3,000 payment, Steve and violated the act. 2. Steve and has breached the common law principles of agency law. True. Under common law agency principles, an agent must disclose all benefits, including additional payments, to their principal. Failure to disclose constitutes a breach of fiduciary duty, specifically the duty of full disclosure. 3. Both 1 and 2 are true. Correct. Steve and's failure to disclose the $3,000 payment violates both the statutory requirements of the Real Estate Services Act and the common law fiduciary duty of full disclosure. Summary: the correct answer is C. Both 1 and 2 are true. Steve and's actions contravene both the statutory requirements of the Real Estate Services Act and the fiduciary duties established under common law agency principles. Question 15. An agent's authority can be created retroactively by their principal by an action called. Correct answer: B. Ratification. Explanation: ratification occurs when a principal retroactively approves an agent's unauthorized actions, thus creating authority after the fact. For example, if an agent acts outside their authority, the principal can ratify or adopt the act, making it legally binding. Other options: 1. Rectification. Incorrect. Rectification is a remedy used to correct a mistake in a written contract, ensuring that the document reflects the party's true intentions. 3. Rescission. Incorrect. Rescission refers to canceling or undoing a contract, restoring both parties to their original positions. 4. Revocation. Incorrect. Revocation is the withdrawal of authority from an agent by the principal, effectively terminating the agent's power to act on their behalf. Summary: The correct answer is B, ratification, as it refers to the retroactive approval of an agent's unauthorized actions by the principal. Chapter 12, Law of Agency, Question 16. Where a licensee is personally involved in a real estate sale, which of the following is not a part of the disclosure requirements under the Real Estate Services Act? Correct answer: C. The licensee must disclose any other properties currently under consideration by the licensee. Explanation: under the Real Estate Services Act, this disclosure is mandatory to avoid conflicts of interest and ensure transparency. Other options: 2. B. The licensee must disclose that they, or an associated company or partnership, are selling their own property. True. Selling their own property is a material fact, and disclosure is required under the Real Estate Services Act to protect all parties involved in the transaction. 3. C. The licensee must disclose any other properties currently under consideration by the licensee. False. There is no requirement under the Real Estate Services Act for a licensee to disclose unrelated properties they are considering. This is not relevant to the transaction in question. 4. D. The licensee must make the required disclosure in writing in the required form prior to entering into any agreement. True. The Act requires that all disclosures related to personal interest in a transaction be made in writing and follow the prescribed format before the agreement is entered into. Summary: the correct answer is C. The licensee must disclose any other properties currently under consideration by the licensee, as this is not a required disclosure under the Real Estate Services Act. Chapter 12, Law of Agency, Question 17. You, as a trading services licensee working in a hot market, have recently listed a property for sale at $850,000. An offer of $840,000 was received at 8:30 this morning. At noon, a second offer of $845,000 was received and a third offer of $850,000 at 2:30 in the afternoon. You will be seeing the seller at 7 o'clock this evening. Which offer is to be presented? Correct answer: A. All of the offers. Explanation: as a trading services licensee, you are required by the rules under the Real Estate Services Act to present all offers to your client unless the client has explicitly instructed otherwise in writing. It is your fiduciary duty to ensure that the seller has full knowledge of all potential offers so they can make an informed decision. Other options: 1. A. All of the offers. Correct. You must present all offers received, regardless of the order or timing, to ensure compliance with your obligations as an agent. 2. B. The offer of $840,000. Incorrect. Limiting the presentation to just the first offer is not compliant with your duty to disclose all material facts. 3. C. The offer of $845,000. Incorrect. Selecting just the highest offer at that moment disregards the later offer of $850,000, which could be in the seller's best interest. 4. D. The offer of $850,000. Incorrect. While this is the highest offer, your duty is to present all offers so the seller can evaluate them and potentially negotiate. Summary: you must present all offers to the seller to fulfill your legal and ethical obligations. The correct answer is A. All of the offers. Chapter 12, Law of Agency, Question 18. What is the key purpose that is achieved when a licensee fulfills Section 54 of the Real Estate Services Rules and provides a consumer with a disclosure of representation in trading services form? Correct answer: A. Informed consent. Explanation: the purpose of providing the disclosure of representation in trading services form under Section 54 of the Real Estate Services Rules is to ensure that the consumer has informed consent. This means the consumer is fully aware of the type of representation they will receive from the licensee, i.e., as a client or an unrepresented party, and understands the implications of that relationship. The form ensures that the consumer understands the licensee's duties and responsibilities in the transaction, enabling them to make an informed decision about representation. Options analysis. 2. B. Undivided loyalty. Incorrect. While undivided loyalty is a fiduciary duty owed to a client, this is not the purpose of the disclosure form. The form clarifies the representation relationship not specific fiduciary duties. 3. C. A promise to pay remuneration/commission, incorrect. The form does not address payment or commission. It focuses on representation. 4. D. Disclosure of interest in trade, incorrect. Disclosure of interest in trade pertains to situations where the licensee has a personal interest in a transaction, which is a separate disclosure requirement under the Real Estate Services Act. Summary: the key purpose of providing the disclosure of representation in trading services form is to ensure informed consent from the consumer regarding the representation relationship. Therefore, the correct answer is A. Informed consent. Chapter 12, Law of Agency, Question 19. Which of the following statements is false under the common law of agency? Correct answer: B. Where the agent does not disclose that they are an agent and enters into a contract with a third party, the principal can have no liability for the contract. Explanation: this statement is false because under the common law of agency, a principal can still be held liable for a contract made by an undisclosed agent, as long as the agent was acting within the scope of their authority. If the agent has the authority to act on behalf of the principal may still be bound by the contract, even if the agency relationship was not disclosed to the third party. Options analysis. A. An agency relationship is created when two persons agree that one will act on behalf of the other. True. This is the fundamental basis for an agency relationship under the common law. B. Where the agent does not disclose that they are an agent and enters into a contract with a third party, the principal can have no liability for the contract. False. The principal can be liable for the contract if the agent was acting within their authority, even if the agency relationship was undisclosed. C. An agent who would not have capacity to enter a contract themselves may be able to make a valid contract on their principal's behalf. True. An agent can create a binding contract for the principal even if the agent lacks capacity themselves, e.g., a minor acting as an agent for an adult principal. D. An agency agreement may be either written or oral or partly written and partly oral. True. Agency agreements can be formed in any of these ways, as long as there is mutual consent and the necessary elements of agency are present. Chapter 12, Law of Agency, Question 20. A gain or reward received by an agent from a third party in connection with their agency relationship with the principal, if it not disclosed to the principal, is known in agency law as. Correct answer: A. A secret profit. Explanation: a secret profit is a gain or reward received by an agent from a third party in connection with their agency duties that is not disclosed to the principal. Under agency law, agents owe fiduciary duties to their principals, including the duty of full disclosure. Accepting any benefit or reward without informing the principal breaches this duty and may result in legal consequences for the agent. Options analysis. A. A secret profit. Correct. This is the specific legal term for an undisclosed benefit received by an agent in connection with their duties. B. A taxable gain. Incorrect. While the profit might be subject to taxation, this term does not describe the concept in agency law. C. Permitted third-party remuneration. Incorrect. Remuneration from a third party is only allowed if it is fully disclosed to and accepted by the principal. Without disclosure, it becomes a secret profit. D. A latent defect. Incorrect. A latent defect refers to a physical issue with a property that is not apparent or easily discoverable, not an undisclosed financial gain. Summary: a secret profit is an undisclosed benefit received by an agent in violation of their fiduciary duties to the principal. The correct answer is A. A secret profit. Chapter 12, Law of Agency, Question 21. Assume that a seller instructs his real estate licensee to make certain oral representations regarding a property that both the seller and the licensee know to be false. If the purchaser later sues the seller and the licensee on the basis of this misrepresentation, then, correct answer: A. The seller will be liable to the buyer because he explicitly authorized the tort. Explanation: both the seller and the licensee can be held liable for fraudulent misrepresentation. Here's why. 1. The seller's liability arises from explicitly authorizing the misrepresentation. Under agency law, a principal, the seller, who instructs an agent, the licensee, To perform a wrongful act, fraudulent misrepresentation is directly liable for the consequences of that act. 2. The licensee's liability arises because an agent cannot escape personal liability for knowingly engaging in illegal or fraudulent conduct, even if they were acting on their principal's instructions. Option C is incorrect because courts generally do not uphold disclaimer clauses that attempt to shield parties from liability for fraud or intentional misrepresentation. Options analysis. 2b. The licensee can escape personal liability by arguing that he was authorized to commit the tort. Incorrect. Licensees remain personally liable for wrongful acts, even if authorized by the principal. 3c. The seller and the licensee will not be liable if there is a clause in the contract of purchase and sale reading, there are no representations, warranties, guarantees, promises, or collateral agreements other than those contained in this written agreement. Incorrect. A disclaimer clause cannot protect against liability for fraud or intentional misrepresentation. 4d. The buyer's only remedy will be a court order against the seller for damages. Incorrect. The buyer can sue both the seller and the licensee for damages resulting from the misrepresentation. Summary. When a seller explicitly instructs a licensee to make false representations, the seller is liable for authorizing the tort, and the licensee cannot escape liability for knowingly engaging in the misrepresentation. The correct answer is A. The seller will be liable to the buyer because he explicitly authorized the tort. Chapter 12. Law of Agency. Question 22. Deborah is a trading services licensee. After providing her best estimate with respect to the value of Susan's property, Deborah lists the property at $600,000. Jennifer, who has learned that Susan's property is situated in the middle of an area to be redeveloped, immediately comes to Deborah with a full price, subject-free, offer. In response to Deborah's surprise reaction to the offer, Jennifer acknowledges that a redevelopment of the area is intended. Deborah does not advise Susan of the redevelopment as it might jeopardize the deal and, in any event, she feels that a redevelopment might cause the value of Susan's property to decrease rather than rise. Susan accepts Jennifer's offer and is delighted that the property sold so quickly. Which of the following statements is true? Correct answer, C. The proposed redevelopment might have affected Susan's decision to sell her property and therefore should have been brought to Susan's attention. Explanation. Deborah, as Susan's trading services licensee, has a fiduciary duty to disclose all relevant facts that might influence Susan's decisions regarding the sale of her property. Failing to inform Susan about the redevelopment is a breach of her duty of loyalty and full disclosure. This information is material because it could significantly impact Susan's decision to sell or the price at which she is willing to sell. Options analysis. A. Susan does not have any claim against Deborah because she received the full listing price for her property. Incorrect. While Susan received the listing price, she may have acted differently if she were aware of the redevelopment. The fact that she received the full asking price does not absolve Deborah of her duty to disclose material information. B. If Deborah had advised Susan of the redevelopment, she would have breached the duty that she owed to Jennifer. Incorrect. Deborah owes a fiduciary duty to Susan, not Jennifer. Her duty is to act in Susan's best interests, which includes disclosing material information that may affect Susan's decisions. C. The proposed redevelopment might have affected Susan's decision to sell her property and therefore should have been brought to Susan's attention. Correct. Deborah had a duty to disclose the redevelopment to Susan because it was material to the sale. D. As long as Deborah honestly believed that the offer was fair, she has satisfied her duty to Susan. Incorrect. A fair offer does not negate Deborah's duty of full disclosure. Her belief about the offer's fairness is irrelevant if material information was withheld. Summary. Deborah breached her fiduciary duty by failing to disclose the redevelopment, which was material information. Chapter 12. Law of Agency. Question 23. In which of the following situations where express authority exists would an agent have authority to act? Correct answer. A. The agent is an infant. Explanation. In agency law, an agent's ability to act on behalf of a principal is not typically affected by the agent's age, provided they are capable of carrying out the specific duties assigned to them. However, 1. An infant, a minor, can still act as an agent, as their role is to represent the principal, not to enter into personal obligations. 2. Mental capacity is crucial for both parties to the agency relationship. If the agent loses mental capacity, they cannot perform the required duties. 3. If the principal is insane, the agency relationship is void, as the principal must have the capacity to appoint an agent. Options analysis. 1. A. The agent is an infant. Correct. An infant can act as an agent because the agent's role is to bind the principal, not themselves. 2. B. The agent loses mental capacity. Incorrect. If the agent lacks mental capacity, they cannot effectively carry out their duties or represent the principal. 3. C. The agent is sane but the principal is insane. Incorrect. If the principal is insane, they cannot validly authorize an agent to act on their behalf. 4. D. None of the above-mentioned agents has authority to act on behalf of the principal. Incorrect. An infant can act as an agent, provided they can perform the required tasks. Summary. The correct answer is A. The agent is an infant. An infant can legally act as an agent because their role is to represent the principal, not themselves.
Question 24. Consider a situation in which the principal is the seller and the agent is the listing agent. Which of the following events will terminate the real estate agency relationship? Correct answer. B. An act of the principal that is inconsistent with the continuation of the agent's authority. Explanation. An agency relationship can be terminated by several means, including mutual agreement, the completion of the agency purpose, or acts inconsistent with the continuation of the agency relationship. Let's evaluate the options. The principal's refusal to accept an offer to purchase presented by the agent where the offer exactly complies with the requirements in the listing contract. Incorrect. While this may frustrate the agent, it does not terminate the agency relationship unless the principal explicitly acts in a way inconsistent with the agreement, for example, withdrawing the property from the market. B. An act of the principal that is inconsistent with the continuation of the agent's authority. Correct. For example, if the principal sells the property themselves, without the agent's involvement or lists it with another brokerage, this act would effectively terminate the agency relationship. C. An offer by the agent to personally purchase the principal's property. Incorrect. While this action might create a conflict of interest, it does not automatically terminate the agency relationship unless the principal decides to terminate it. D. The revocation of an offer to purchase by the offeror before the principal can accept it. Incorrect. This event does not affect the agency relationship between the principal and agent. It merely impacts the specific transaction.
Chapter 12, Law of Agency, Question 25. Gertrude is the listing licensee for Annika in the sale of her property. Gertrude receives an offer from a buyer for Annika's property. When is Gertrude required to provide a disclosure of expected remuneration, payment form to Annika? Correct answer D. When Gertrude presents the offer to Annika. Explanation. Under the real estate services rules, a licensee must provide a disclosure of expected remuneration payment form when presenting an offer to the seller. This ensures the seller is fully informed about the remuneration the licensee expects to receive before making any decisions about the offer. Let's evaluate the options. 1. A. If Annika decides to make a counteroffer to the buyer. Incorrect. The disclosure must occur when the offer is presented, not at the point of making a counteroffer. 2. Before the deadline for acceptance of the offer. Incorrect. While this ensures timely disclosure, the rule specifically requires disclosure at the time the offer is presented. 3. C. Only when Annika decides to accept the offer. Incorrect. The disclosure must be made earlier before any decision is made to ensure informed consent. 4. D. When Gertrude presents the offer to Annika. Correct. The rule mandates that the disclosure of expected remuneration be provided when the offer is first presented to the seller. Summary. The correct answer is D. When Gertrude presents the offer to Annika. This ensures transparency and compliance with the real estate services rules. Question 26. In which of the following situations will the agency authority continue to exist? Correct answer. D. None of the above. Explanation. An agency relationship can be terminated under certain circumstances, as described in the provided options. Let's analyze them. 1. A. Lauren lists his house for sale with Steve. The house burns down. Incorrect. The destruction of the subject matter, the house, terminates the agency relationship because there is no longer a property to sell. Lorne enters into an exclusive listing agreement with his agent Mark. Lorne then sells the property himself without Mark's assistance. Incorrect. Even though Lorne sold the property, the agency relationship likely terminates because the purpose of the listing agreement, to sell the property, has been fulfilled. However, Lorne may still owe commission depending on the terms of the listing contract. C. Lorne tells his agent over the phone that he no longer has the authority to sell his house. Incorrect. If the principal revokes the agent's authority, as in this case, the agency relationship is terminated. 4. D. None of the above. Correct. In all the situations provided, the agency authority ceases to exist.
Question 27. Robert asks Whitney to act as his agent at the auction of the effects of a deceased rock star. Robert was an enthusiastic fan of the deceased and tells Whitney that no matter what, he must become the owner of the deceased's vintage Rolls-Royce, which is painted in a most attractive paisley motif. Whitney is also told that under no circumstances is she to come away from the auction without buying this automobile for Robert. At the auction, the rock star's paisley Rolls-Royce is offered with a second pinstriped version of the vehicle. The two vehicles are offered as a package, and accordingly, Whitney, as the successful bidder, purchases both vehicles for Robert. If asked to discuss Whitney's scope of authority, you would correctly answer that during the course of the fact pattern, Whitney was provided with. Correct answer, C, both express and implied authority. Explanation. 1. Express authority. Robert explicitly instructed Whitney to purchase the paisley Rolls-Royce at any cost. This is an example of express authority, as Whitney was directly authorized to act in this specific capacity. 2. Implied authority. While there was no explicit instruction to purchase both vehicles, Whitney's decision to buy the pinstripe Rolls-Royce alongside the paisley one was a necessary action to fulfill her express authority, since the vehicles were offered as a package. Implied authority arises when an agent takes reasonable actions to accomplish the goals set by their principal's express instructions. Summary: Whitney had express authority to secure the paisley Rolls-Royce for Robert, and implied authority to purchase the additional vehicle because it was a reasonable and necessary means to fulfill Robert's instruction. Therefore, the correct answer is C, both express and implied authority.
Question 28. If a licensee falls into the narrow exception in the rules for the practice of dual agency, they must ensure that which of the following agreements is entered into before providing services within the dual agency relationship. Correct answer. A. An agreement regarding conflict of interest between clients. Explanation. When a licensee practices dual agency under the narrow exception allowed by the real estate services rules, they are required to ensure that the parties involved understand and agree to the dual agency relationship. This includes addressing potential conflicts of interest. The agreement regarding conflict of interest between clients is the formal document that confirms both clients are aware of and consent to the arrangement, ensuring transparency and compliance with the rules. Why not the other options? B. A written agreement of dual agency. While the concept of a written agreement is relevant, the specific document required by the rules is the agreement regarding conflict of interest between clients. C. A disclosure of interest in trade form. This form is for disclosing a licensee's personal interest in a trade, not for managing dual agency relationships. D. A disclosure of risks to unrepresented parties form. This is used when dealing with unrepresented parties, not for dual agency situations where both parties are clients. Summary: to comply with the rules in dual agency situations, the licensee must ensure an agreement regarding conflict of interest between clients is entered into. Hence, the correct answer is A. Chapter 12, Law of Agency, Question 29. A person whom an agent represents is known in law as the. Correct answer, B. Principal. Explanation. In the context of agency law, the principal is the person or entity that an agent represents. The agent acts on behalf of the principal and has a fiduciary duty to act in the principal's best interests. Why not the other options? A. Buyer. The buyer may or may not be the principal, depending on who the agent represents. The term buyer is specific to one side of a transaction, not a general term for the party represented. C. Client. While client is a commonly used term in practice, the legal term under agency law is principal. D. Seller. Similar to buyer, the seller could be the principal if the agent represents the seller, but principal is the broader, correct legal term. Summary. The correct legal term for the person whom an agent represents is principal. Therefore, the answer is B. Question 30. Where a principal adopts a contract that their agent entered into without any authority. Correct answer. C. The agent is given authority retroactively to enter into that contract. Explanation. When a principal adopts, ratifies, a contract that their agent entered into without authority, the act of ratification grants the agent retroactive authority. This means that, in effect, the agent's actions are validated as if they had the authority at the time of the contract. Why not the other options? A. The third party is not obligated to honor the contract if they do not wish to. Once the principal ratifies the contract, the third party is bound by its terms, just as the principal is. B. The principal can sue the agent for breach of warranty of authority. This does not apply here because the ratification by the principal validates the agent's actions, eliminating grounds for such a claim. D. The agent becomes a party to that contract. The agent is not a party to the contract. Once ratified, the contract exists between the principal and the third party. Summary. When a principal ratifies an unauthorized contract, the agent is retroactively granted authority to act, making C the correct answer. Question 31. In a scenario where a licensee is directly or indirectly acquiring an interest in real estate and has complied strictly with the disclosure requirements of the Real Estate Services Rules, which of the following statements is true? Correct answer. B. The common law may still require further disclosure. Explanation. Even when a licensee complies strictly with the disclosure requirements under the Real Estate Services Rules, the common law of agency imposes additional duties. These duties include disclosing any material facts that could affect the principal's decision, such as the potential for a conflict of interest or other relevant information that goes beyond statutory requirements. Why not the other options? A. No conflict of interest and duty could exist. Even with strict compliance, a conflict of interest could still arise, requiring further disclosure to fulfill common law obligations. C. They may make a secret profit. If the licensee complies with all disclosure requirements, including under common law, there would be no secret profit, as the principal would be fully informed. D. They are safe from any sort of liability arising from that purchase. Compliance with the Real Estate Services Rules does not eliminate liability under common law if further disclosure is required or if there are other breaches. Summary. The common law of agency may impose additional requirements beyond the statutory rules, ensuring that the principal's interests are fully protected. Thus, B is the correct answer. Question 32. Where a principal of an agent has acted in such a manner as to lead third parties to believe that their agent has authority to perform certain acts on their behalf, and the third party, when dealing with the agent, reasonably believes that the agent has the authority that they represent, the agent is said to have. Correct answer, D, apparent authority. Explanation. Apparent authority arises when a principal's actions or conduct reasonably lead a third party to believe that the agent has authority to act on the principal's behalf, even if the agent does not have actual authority. The key elements are: 1. Representation by the principal. The principal's behavior or statements create the impression of authority. 2. Reasonable belief by the third party. The third party relies on this belief when dealing with the agent. This concept protects third parties who reasonably rely on an agent's perceived authority. Why not the other options? A. Actual authority. This refers to authority explicitly or implicitly granted by the principal to the agent, not to authority perceived by third parties. B. Express authority. A subset of actual authority. This is explicitly stated in words, written or oral, by the principal to the agent. C. Legal authority. This is not a specific term in agency law related to the question. Summary. When the principal's actions lead a third party to reasonably believe in the agent's authority, it is called apparent authority. Thus, D is the correct answer. Question 33. Which of the following statements concerning an open listing is false? Answer. B. The Real Estate Services Act requires all listings to always be in writing. Explanation: the Real Estate Services Act does not require all listings to always be in writing. While it is good practice and often required by brokerage policy for clarity and enforceability, verbal agreements can still create valid agency relationships under certain conditions. However, written agreements are preferred to avoid disputes. Why not the other options? A. Under an open listing, a commission will only be paid to the agent who is the effective cause of the sale. This is true. In an open listing, only the agent who procures the buyer and is the effective cause of the sale is entitled to a commission. Under an open listing, the seller is free to dispose of the property independently without any liability to pay commission to an agent. This is true. If the seller finds a buyer without any agent's involvement, they owe no commission to any agent under an open listing. D. Under an open listing, a seller is free to use the services of any number of brokerages. This is true. Open listings allow the seller to list the property with multiple agents and brokerages simultaneously. Summary: the false statement is B, because the Real Estate Services Act does not require all listings to be in writing, although it is strongly recommended. Question 34. Which of the following statements respecting a real estate agency relationship is true? Correct answer: D. None of the above statements are true. Explanation: A. The interests of the agent take priority over those of the principal. This is false. Under agency law, the agent must act in the best interests of the principal and cannot prioritize their own interests over those of the principal. B. The buyer of the property is always owed the agent's primary duty to act solely for their benefit. This is false. The agent's primary duty is owed to their principal, not to the other party in the transaction. If the agent represents the seller, their duties are owed to the seller and vice versa. C. The agent is an employee and works under the direct control and supervision of their principal. This is false. Real estate agents often work as independent contractors and not as employees. While they owe fiduciary duties to their principal, they are not under the direct supervision or control of the principal in the same way an employee would be. Summary: none of the listed statements about real estate agency relationships are true, making D the correct answer. Question 35. Which of the following events will terminate an agency relationship? Correct answer: D. All of the above. Explanation: an agency relationship can be terminated through various events, including 1. Revocation of the agency by the principal. The principal has the right to revoke the agent's authority unless doing so violates a contractual obligation. 2. Frustration. If the agency agreement cannot be performed due to circumstances beyond the control of either party, e.g., the destruction of the subject matter, the relationship is terminated. 3. Performance. Once the agent has completed the task or fulfilled the purpose for which the agency relationship was created, the relationship ends. Summary: correct answer. All the events listed, revocation, frustration, and performance, can terminate an agency relationship, making D the correct answer. Question 36. Which of the following statements is true? Correct answer: B. Under the designated agency system, while the brokerage contracts with the seller or buyer, an individual licensee is appointed to act as the sole agent of that seller or buyer. Explanation: 1. A listing contract is not a specialized form of agency contract. False. A listing contract is a specialized form of agency contract where the brokerage agrees to act as the agent for the seller to market and sell their property. 2. B. Under the designated agency system, while the brokerage contracts with the seller or buyer, an individual licensee is appointed to act as the sole agent of that seller or buyer. True. In the designated agency model, the brokerage enters into the agency agreement, but a specific licensee is assigned to represent the client's interests exclusively, avoiding conflicts of interest within the brokerage. 3. C. Real estate brokerages always work on behalf of the seller in respect of a real estate transaction. False. Brokerages can represent either the seller or the buyer, depending on the agreement in place. 4. D. An agent's authority to bind their principal depends entirely on the express authority given by the principal and not upon implied, usual, or customary authority. False. An agent's authority can arise from express, implied, usual, or customary authority. Summary: The designated agency system involves assigning an individual licensee to act solely for a client, making B the correct answer. Chapter 12, Law of Agency, question 37. In which of the following ways would an agency contract not be terminated? Correct answer, D, by an act of a third party inconsistent with the continuation of authority. Explanation, A, by the death of one of the parties. True. The death of either the principal or the agent typically terminates an agency contract unless otherwise agreed. B, by the legal doctrine of frustration. True. Frustration occurs when an unforeseen event renders the performance of the contract impossible or fundamentally changes its nature, thereby terminating the agency relationship. C, by a letter of termination by the principal provided to the agent. True. A principal can revoke an agency relationship by providing notice of termination to the agent. D, by an act of a third party inconsistent with the continuation of authority. False. A third party's actions do not inherently terminate an agency relationship unless they cause frustration or another valid reason for termination is triggered. Summary. An agency relationship cannot be terminated solely by an act of a third party, making D the correct answer. Question 38. Which of the following is not a duty that is owed by a principal to their agent? Explanation. 1. A. The duty to indemnify the agent. True. A principal has a duty to indemnify, reimburse the agent for losses or expenses incurred while acting within the scope of their authority. 2. The duty to remunerate the agent. True. A principal is typically obligated to pay the agreed-upon remuneration or commission as specified in the agency agreement. 3C. The duty to comply with the agency agreement. True. A principal is bound to fulfill the terms and conditions outlined in the agency agreement. 4D. The duty to avoid conflicts of interest with the agent. False. While agents owe a fiduciary duty to avoid conflicts of interest with their principal, the principal does not owe the same duty to the agent. This is not a recognized duty in the principal-agent relationship. Summary. The principal does not have a duty to avoid conflicts of interest with the agent, making D the correct answer. Question 39. When an agent acting within the scope of their authority and having disclosed that they are acting as an agent enters into a contract with a third party, the parties to that contract are. Correct answer, B, the principal and the third party. Explanation. 1. Principal-agent relationship. When an agent acts within the scope of their authority and discloses their agency status, the agent is merely a representative of the principal. 2. Parties to the contract. The principal, through the agent's authorized actions, is bound to the third party. The agent is not a party to the contract unless they exceed their authority or fail to disclose their role as an agent. 3. Key points. The agent facilitates the contract but is not bound by it. The contract is enforceable between the principal and the third party. Summary. The correct answer is B, the principal and the third party, because the agent's role is to bind the principal to the contract.
Question 40. An agent's duty to the principal not to make a secret profit means that an agent must keep the principal fully informed about which of the following. Correct answer, C. All of the actual benefits and prospective benefits accruing to the agent as a result of the agency relationship. Explanation 1. Definition of secret profit. A secret profit refers to any benefit, monetary or otherwise, that an agent receives as a result of their position, which is not disclosed to the principal. Second agent's obligation. The agent must inform the principal of both actual and potential benefits they may derive from the agency relationship. Failing to do so is a breach of the fiduciary duty owed to the principal. 3. Exclusions. The agent's personal business dealings, unrelated to the agency relationship, and tax returns are not required disclosures. Limiting disclosure to actual profits received, option D, ignores potential benefits, which must also be disclosed. Summary. The agent must keep the principal fully informed about all actual and prospective benefits arising from the agency relationship, ensuring transparency and avoiding conflicts of interest.
Question 41. Which one of the following types of authority would not provide an agent with sufficient authority to create a binding contract between their principal and a third party? The correct answer is C. Assumed authority. Explanation. Assumed authority is not a recognized legal term for an agent's ability to bind a principal to a contract. The other types, implied authority, apparent authority, and express authority, are all legal ways an agent can have the power to create binding contracts on behalf of a principal. Why not other options? A. Implied authority. Authority inferred from actions necessary to fulfill express instructions can bind the principal. B. Apparent authority. Authority based on the third party's belief that the agent has power can bind the principal. D. Express authority. Explicit authority given by the principal can bind the principal. C. Assumed authority. Not a legal term, so it doesn't bind the principal. Summary. Implied, apparent, and express authority can bind a principal to a contract, as they grant the agent the ability to act on the principal's behalf. Assumed authority is not a recognized legal concept, so it does not provide the agent with binding power.
Question 42. Which of the following events will terminate a real estate agency relationship? The correct answer is C. Assumed authority. Assumed authority is not a recognized legal term for an agent's ability to bind a principal to a contract. The other types, implied authority, apparent authority, and express authority, are all legal ways an agent can have the power to create binding contracts on behalf of a principal. A. Implied authority. This refers to the authority an agent has to perform tasks that are necessary or incidental to carrying out their express instructions. Even if not explicitly stated, this type of authority allows an agent to bind the principal in situations where such actions are reasonably expected. For example, if an agent is authorized to manage a business, they might have implied authority to buy supplies. B. Apparent authority. This arises when a third party believes that the agent has authority to act on behalf of the principal, even if the principal did not give the agent express authority. If a principal's actions lead a third party to reasonably believe that the agent has the authority to act, the principal can be bound by the agent's actions, even if the agent doesn't actually have that authority. For instance, if a company employee signs a contract, the third party may assume they have authority based on their position. D. Express authority. This is the most straightforward form of authority, where the principal explicitly grants the agent permission to act on their behalf. For example, a written or verbal agreement that clearly states the agent's powers to enter into contracts would create binding obligations for the principal. In contrast, assumed authority is not a formal or recognized legal term in agency law, making it the incorrect answer. Summary. Implied, apparent, and express authority can bind a principal to a contract, as they grant the agent the ability to act on the principal's behalf. Assumed authority is not a recognized legal concept, so it does not provide the agent with binding power.
Question 43. The remuneration figures contained in the disclosure to sellers of expected remuneration form. The correct answer is A. Can be disclosed as a percentage or a dollar amount. Explanation. The remuneration figures in the disclosure to sellers of expected remuneration form can be provided either as a percentage or a specific dollar amount, giving flexibility in how it's presented. Other options. A. Only if the agreement is for a term longer than 12 months. This is incorrect, because the agreement must be signed regardless of the term length. C. At any time during the listing period. This is incorrect, because the agency agreement must be signed at the time the listing is signed, not at any time during the listing period. D. After the agreement is amended. This is incorrect, because the agency agreement must be signed initially, not just after amendments. Summary. The remuneration figures in the disclosure to sellers of expected remuneration form can be disclosed as either a percentage or a dollar amount. It doesn't need to match the listing contract format and doesn't have to be expressed only as a dollar amount if the remuneration is in money. Question 44. What is the purpose of restating many of the common law fiduciary duties owed by a licensee to a client in the real estate? The correct answer is, a breach of a fiduciary duty may also result in disciplinary proceedings by the British Columbia Financial Services Authority. Explanation: restating common law fiduciary duties in the real estate services rules serves to ensure that a licensee's actions are subject to disciplinary measures by the British Columbia Financial Services Authority, BCFSA, in addition to any legal consequences from a breach of fiduciary duty. Other options. In the case of a breach of fiduciary duty, the client will be able to receive twice the amount of damages. This is incorrect. The purpose isn't to double the damages, but to provide clarity on licensee duties and allow for enforcement. It allows a client to also bring action against the licensee for a breach of the rules. While the rules provide enforcement, they don't automatically allow clients to bring action for breaches. Disciplinary actions are typically pursued by regulatory authorities. It tends to be easier to prove a violation of the rules, allowing judges to rule in favor of the client more often with the rules than with the common law fiduciary duties. This is incorrect, as proving a breach of fiduciary duty or violation of the rules follows due process and does not necessarily make it easier to win. Summary: restating common law fiduciary duties in the real estate services rules ensures that breaches can lead to both legal consequences and disciplinary action by the BCFSA. Question 45. In which of the following circumstances will an agent not be personally liable for their actions? The correct answer is A. The agent, identified as such, is mistakenly believed by a third party to be contracting as a principal. Explanation: if the agent is identified as an agent and a third party mistakenly believes they are acting as a principal, the agent is typically not personally liable because they are acting on behalf of the principal. Other options. B. The agent has no authority to act as an agent. This is incorrect. If the agent has no authority, they can still be personally liable for their actions. C. The agent commits a tort. This is incorrect. If the agent commits a tort, they can be personally liable, even if acting on behalf of the principal. D. The agent fails to disclose that they are an agent. This is incorrect. If the agent fails to disclose their status, they can be personally liable for any resulting confusion or harm. Summary: principal. An agent is typically not personally liable if identified as such, but mistakenly believed by a third party to be acting as a principal.
Chapter 12, Law of Agency. Question 46. Coralie asked Tim to sell her car and her mountain bike for her while she was away on holiday. She gave Tim the keys to the car and told him to accept any price in excess of $1,700 for the car and $300 for the bike. Which of the following is an example of implied authority? The correct answer is C. When Charisse was viewing the car, she noticed a small roof rack sitting in Coralie's garage. She said that she would like to buy the rack to carry her camping gear on Coralie's car. Tim said that he would include the rack in the sale for an additional $75, to which Charisse agreed. When Coralie returned, she told Tim that she was pleased that he had sold the rack, since she had no more use for it. Explanation: implied authority allows an agent to do things that are necessary to carry out their express duties, even if not specifically stated. Tim didn't have explicit permission to sell the roof rack, but his action was reasonable and necessary to finalize the car sale. Other options. A. Tim sold the car to Charisse for $1,750. This is not an example of implied authority, as Tim acted within the boundaries of his authority by accepting more than the $1,700 minimum. B. Tim allowed Charisse to test drive and inspect the car. This is not an example of implied authority, as Tim's action was likely part of the standard procedure for selling a car, rather than something implied by the agreement. D. Tim sold the bike for $260. This is not implied authority, as selling the bike for less than the agreed price is outside the authority given to Tim, even though Coralie later accepted the money. Summary: implied authority allows an agent to take reasonable actions necessary to fulfill their task. In this case, Selling the roof rack was a reasonable action within the context of selling the car.
Question 47. Julie is acting as the listing licensee for a property owned by her client, George. Julie also represents a client, Ahmed, whom she is helping find a suitable property to buy. Ahmed becomes interested in purchasing George's property. Julie would like to continue to represent George as a client in the sale of his property, while releasing Ahmed as a client. To do this, Julie must enter into an agreement regarding conflict of interest between clients, with. Answer is C. Both George and Ahmed. Explanation. When there is a conflict of interest between two clients, the licensee must have an agreement regarding conflict of interest between clients with both clients. This ensures that both clients are aware of and agree to the situation, particularly when one client is being released while the other continues to be represented. Other options. A. George, the continuing client, only. This is incorrect, because both clients need to be involved in the agreement. B. Ahmed, the released client, only. This is incorrect, because George also needs to be part of the agreement since he is the continuing client. D. Neither George nor Ahmed, as the agreement regarding conflict of interest between clients must only be agreed to by Julie's managing broker. This is incorrect. The agreement must be signed by both clients, not just the managing broker. Summary. Julie must enter into an agreement regarding conflict of interest with both George, the continuing client, and Ahmed, the released client, to manage the conflict of interest properly.
Chapter 12, Law of Agency, Question 48. Which one of the following is false? An agent's authority to act on behalf of their principal may arise. Answer is B, contingently. Explanation. Authority to act on behalf of a principal may arise expressly through explicit agreement, by implication through necessary actions, or by ratification, approval of actions after they are performed. However, authority does not arise contingently, which means subject to certain conditions or events that are not generally recognized as a way to create authority. Other options. A. Expressly. This is true. Express authority comes from direct, clear communication between the principal and the agent. C. By implication. This is true. Implied authority arises from the agent's role and what is necessary to perform their duties. D. By ratification. This is true. Ratification occurs when the principal approves an action taken by the agent that was initially done without authority. Summary. Authority can arise expressly by implication or by ratification, but not contingently. Chapter 12, Law of Agency, Question 49. Which of the following statements is true with respect to listing contracts? The correct answer is D. None of the above statements is true. Explanation. A. While a listing contract is a contract between the brokerage and the seller, the buyer is bound to some of the terms contained in the contract. This is incorrect. The listing contract is between the brokerage and the seller, and the buyer is not directly bound by the terms of the listing contract. B. It is not necessary that an exclusive listing contain a specified duration or commencement date. This is incorrect. An exclusive listing must contain a specified duration and commencement date to be valid. C. The open listing provides better protection for the agent than the exclusive listing. This is incorrect. An exclusive listing generally provides better protection for the agent, as it guarantees them a commission if the property is sold, regardless of who finds the buyer. Summary. None of the statements about listing contracts is true. Chapter 12, Law of Agency, Question 50. Which of the following is a key purpose of the disclosure of risks to unrepresented parties form? The correct answer is A. To encourage unrepresented parties to obtain independent professional advice in respect of the trade in real estate. Explanation. The key purpose of the disclosure of risks to unrepresented parties form is to inform unrepresented parties about the potential risks of not having professional representation and to encourage them to seek independent advice before proceeding with the real estate transaction. Other options. B. To advise unrepresented parties of their right to report a licensee to the British Columbia Financial Services Authority. This is incorrect. The form's purpose is not to focus on reporting a licensee, but rather to encourage independent advice. C. to encourage unrepresented parties to enter into an agency agreement with the licensee if the licensee's acts give rise to agency by implication. This is incorrect. The form does not push for agency agreements. It encourages independent professional advice. D. To suggest that unrepresented parties withdraw from a particular transaction if they do not find a licensee to represent them in that transaction. This is incorrect. The form does not suggest withdrawal from a transaction, but rather encourages obtaining advice. Summary: the Disclosure of Risks to Unrepresented Parties form aims to encourage unrepresented parties to seek independent professional advice regarding their real estate transactions. Question 51. Where an agent with express authority enters into a contract with a third party on behalf of their principal, and the third party knows they are an agent, who will the law recognize as parties to that contract? The correct answer is C, the principal and the third party. Explanation: when an agent acts with express authority and enters into a contract with a third party, the law recognizes the principal and the third party as the parties to the contract, as the agent is acting on behalf of the principal. The agent is not a party to the contract in this case, even though they were acting as an intermediary. Other options: A, the agent and the third party. This is incorrect. The agent is acting on behalf of the principal, so the agent and the third party are not the primary parties to the contract. B, the agent, the principal, and the third party. This is incorrect. The agent is not a party to the contract in this case. Only the principal and the third party are. D, none of the above. This is incorrect, because the correct answer is option C, which recognizes the principal and the third party as the parties to the contract. Summary: in a contract where an agent acts with express authority, the law recognizes the principal and the third party as the parties to the contract.